applying contract law to real-world transaction scenarios. By this point in the course, we have explored the foundational principles that create enforceable contracts, including offer, acceptance, mutual agreement, fraud considerations, drafting accuracy, and the essential requirements that make contracts legally binding. While these legal principles are critical to understand, real estate professionals rarely encounter contract law in a theoretical setting. Instead, contract issues typically appear during real-world transactions where communication errors, misunderstandings, or documentation problems can quickly lead to disputes. Real estate transactions often involve multiple parties, tight deadlines, and complex negotiations. Because of these moving parts, even a small mistake in communication or documentation can create confusion regarding the intentions of the parties. Understanding how these issues arise helps licensees recognize potential risks early and prevent problems before they escalate into legal disputes. Arizona real estate professionals are expected to exercise reasonable care and diligence under AAC R428-1101, which includes managing transaction risks through clear communication and proper documentation. Real-world contract formation scenarios. Consider a situation in which a buyer submits an offer to purchase a property and the seller verbally agrees to the terms during a phone conversation with the listing agent. The buyer believes the agreement is complete and begins scheduling inspections. However, the seller later signs a contract with a different buyer who submitted a higher offer. In this scenario, the buyer assumed that the verbal agreement created a binding contract. In reality, most real estate contracts must be reduced to writing and signed by the parties to become enforceable. Under the Statute of Frauds, ARS, paragraph 44-101, agreements involving the sale of real property must be in writing to be legally enforceable. Because the seller never signed the written contract, no enforceable agreement existed. Situations like this illustrate why real estate professionals must clearly explain to clients that negotiations do not create binding agreements until the contract is fully executed by all parties. Miscommunication between parties. Miscommunication is one of the most common causes of real estate disputes. Because transactions often involve buyers, sellers, agents, lenders, inspectors, and escrow officers, information may pass through several individuals before reaching the final decision makers. For example, a buyer may request a repair during the inspection period and assume the seller has agreed to complete the repair before closing. If the request was not properly documented or confirmed in writing, the seller may interpret the conversation differently. This misunderstanding may only become apparent shortly before closing, creating tension between the parties and potentially delaying the transaction. Real estate professionals reduce these risks by ensuring that all agreements are documented in writing and incorporated into the contract or appropriate addenda. Written communication eliminates ambiguity and provides clear evidence of the parties' intentions. Improper modifications to contracts. Another common risk arises when parties attempt to modify an existing contract without properly documenting the changes. Real estate contracts frequently evolve as inspections occur, financing terms change, or closing timelines shift. If the parties agree to modify a contract, the modification must generally be documented in writing and signed by all parties involved. Informal changes communicated through email or verbal discussions may not be enforceable if they are not incorporated into the official contract documents. For example, a buyer and seller may verbally agree to extend the closing date by several days. If this extension is not documented in a written amendment, the original closing deadline remains legally enforceable. Failure to properly document the extension could place one party in default, even though both parties believed they agreed to modify the contract. Lessons learned from disputed transactions. Real estate disputes often reveal important lessons about the importance of documentation and communication in contract formation. Many disputes occur not because the parties intended to act unfairly, but because expectations were not clearly documented. One of the most valuable practices for real estate professionals is maintaining clear records of all transaction communications and ensuring that every change to the agreement is reflected in the written contract. Careful documentation protects both the client and the licensee by providing a clear record of the transaction. Another important lesson involves managing client expectations. Buyers and sellers may assume that certain actions automatically create legal obligations when, in fact, the contract requires additional documentation or signatures. By educating clients about the contract process, licensees help prevent misunderstandings that could lead to disputes. Online discussion. 1. Question: Why do verbal agreements often lead to confusion in real estate transactions? Answer: verbal agreements may be interpreted differently by the parties and may not be legally enforceable under the statute of frauds. Real estate contracts involving property transfers generally must be in writing and signed by the parties to create a binding agreement. 2. Question: how can real estate professionals reduce the risk of miscommunication during transactions? Answer: professionals can reduce risk by documenting all agreements in writing, confirming important communications, and ensuring that contract modifications are properly executed through written amendments. 3. Question: why must contract modifications be documented in writing? Answer: written modifications ensure that all parties clearly understand the updated terms of the agreement and provide enforceable evidence of the changes if disputes arise.